Ramosha Feinstein, years and decades ago, used to complain that he got shilas in every area of halacha except for two. There were two areas he felt people didn't ask what they were supposed to ask. That was the area of how to distribute their tzedakah money and how they should be educating their kids, the educational system. He felt that people didn't ask that, and they needed to. And Baruch Hashem, today that's changed. But there's still an area of halacha where people don't ask, they don't even know they need to ask, and the consequences can be very serious. And that is the area of estate planning and halachic wills. I think that years and years and years ago, there wasn't even an awareness that there is an issue, and people ended up with a lot of problems. One of the problems is that if you don't write a will, you're opening the door for machlokas in the family. I can't tell you how many families I have seen literally ripped apart because of money. It's quite an amazing thing. The families are okay, everything is, and all of a sudden, right, the head of the family dies and there's a big estate, and all of a sudden they're ripping each other apart over the money. And it's even great families, and it could be over little tiny things. I don't want to even describe specific instances that I've seen, but it has the potential for disaster. And therefore, a will defining very clearly how you want your assets to be distributed is an imperative to avoid machlokas. That's one thing. But then there's also a halachic problem, because if the will is not done properly, then it's very possible that the division will be done by a beit din that in our culture is really very unfair. And it could also end up having no relationship to what the person who passed away, what that person really wanted, because the halacha is very clear on how inheritance is distributed. And there are many halachic ways to make sure that the inheritance is distributed the way you want, but it has to be constructed in the will in a way that stands up to Beit Din. And then Pinchas and Yaakov are going to bring to the table the interface between a will that stands up in Beit Din to how that will stand up in a secular court. Because some of the solutions in halacha create huge tax problems if it's structured in a certain way. Because there's gift tax and all kinds of things that maybe in halacha you've solved it and you got yourself into a tax problem. So this has become the area of halacha. Excuse me. This is the area of halacha where there's not enough attention being paid, and again, families can get destroyed. The relationship between families, it's, if you've never experienced it, no, it's fine, no problem. My kids are going to just get along, until the rubber hits the road, and it's unpredictable how people react when there's a lot of money at stake. And I mean, there was just now, maybe Pinchas saw it, was just literally on one of the Haredi websites that there was a son got the father to sign a will that gave the son all of the assets. And the two siblings took it to Beit Din or court. I don't remember what it was. I think it was probably to Beit Din, and saying the father was senile. The father was senile when he signed it. Okay, and they had to prove that he was senile because the son tried to just take away all the assets by getting the father to sign a will, turning everything over to him. All right, and you see, you've got to prepare and protect and make the will in a way that's legally binding, halachically binding, and reflects what the parents want. And with that, I'll turn it over to Pinchas and Yaakov, where they can probably open the door for the problems that exist and how they have come up with tremendous, very valuable and very logical and implementable solutions.
So thank you, Rabbi Kalinsky, for the introduction. For those of you who don't know me personally, my name is Pinchas Koven. I'm an alumnus of the yeshiva. I was in the first generation back in the early 1980s, and I have stayed connected to the yeshiva ever since then for many, many years. And I think it's for Yaakov and myself, both of us who learned in the yeshiva, it's a real zchut for us to be doing this evening for other alumni. And it's a way for us to give something back to the yeshiva and to give something back to the wonderful community of alumni. I'd first like to do what we call in Hebrew, tiyum tzipiyot, which is coordinate our expectations. We have a lot to do tonight. And there are certain things which we're not going to talk about and we can't do. And we're going to define those. When a person comes to make a will, there are four big obstacles standing in his way. First of all, he might not know the law. Second of all, he might not know the halacha. Third of all, he might not understand the nature of his assets and how those assets need to be taken care of in the framework of the will. And the fourth is the unspoken problem, the elephant in the room, which is the emotional barrier. There can be two emotional barriers when we make a will. The first emotional barrier is that some people have a hard time accepting the fact that they eventually are going to die. I even have a client who paid me the retainer, started working on his will. I sent him a first draft, I sent him a second draft, and then I didn't hear from him for half a year. And I wrote back and I said, "What's going on? What's happened?" He says, "Well, to tell you the truth, I freaked out. I had a hard time dealing with the fact that I'm going to die. But I got over it, and here I am." So you can see that not only a person who hasn't started, but even a person who's in the middle of the road can freak out over this issue. If I do a good job, if Yaakov and I do a good job regarding those first three issues, learning the law, learning the relevant halacha, and learning the facts regarding your assets, in my opinion, we can reduce almost to zero the anxiety that people have regarding making a will. There still is another outstanding issue which might exist for some people, an emotional issue, which is that they have certain issues, problems within the family. Those are not, we're not going to talk about that at all tonight. Those are things that we deal with on an individual level when they come up. We are assuming that you know absolutely nothing, that maybe you don't even know what the definition of a will is. And that's quite okay. We're working from the assumption that you don't know. And I ask forgiveness for those of you who might know something. Maybe you've even made a will before. You understand these things. Some of you might be lawyers. I beg forgiveness from all of you, but we are shooting for the lowest common denominator of shared understanding so that we can all build from the bottom up. Yaakov and I are not selling anything tonight. This is a purely informative evening. We're trying to give you the tools to empower you to understand the choices that you can make. And it's nothing more than that. 2 hours from now, when this Zoom is over, you should have a basic understanding of the basic terminology, the considerations, the choices, and the possibilities. You will know the risks involved if you do not make a will at all. You will know the risks involved if you don't make a halachic will. And you will also learn a lot of things that you can do on your own, and that in fact you should do on your own without a lawyer, that don't cost anything. I call those things homework, and I'm going to give you at least 2 or 3 different homework assignments during my talk. We have a mixed audience according to the sign-up. Some are Americans living in America, some are Israelis, in other words, Israeli Americans who have made Aliyah, who are Israeli citizens, and some people might have property only in America, only in Israel, and some of them might have property in both countries. We're going to try to address all of those types, but our classic clientele, our sweet spot for our firm is serving people like ourselves, Israeli Americans who have made Aliyah. And the things I'm about to say, in terms of American law, really are pretty much the same thing as regarding Canadian law, British law, and any law of an Anglo-Saxon country. There are differences, but we can't cover all of them in a talk like this. But you can work from for the purpose of tonight's discussion. You can work from the assumption that when I say American, it's true also regarding Canada or Great Britain or something similar. The 2 hours will be divided as follows. The first hour and a little bit more than that, I will be presenting to you the fundamentals of American law and Israeli law regarding wills. In the second half of my talk, I'm going to be talking about the halacha and the halachic issues that arise when a person in the modern day and age draws a modern will. Afterwards, my partner, Yaakov Greiff, will lecture for about 40 minutes regarding the nuts and bolts, the practica, the logistics. How do we actually do this? What does it look like? How do we pull this off? And in the last 10 minutes, we're going to leave for questions. Now, Yaakov and I are willing to stay even longer than the 10 minutes allotted for questions, provided that Donna agrees to leave the Zoom on. That's up to her. But regarding questions that you might be posting, I'm not going to be looking at any questions that are posted on the screen. Donna's going to be sifting through them while I talk. I'm going to be much too involved in the lecture to even pay attention to what's going on. So there's no reason to ask me questions as if I would answer them along the way. It's not going to happen. And just save the questions for the end. Well, I would suggest that you do equip yourself with a piece of paper and a pen, because I am going to be defining terms that you might want to jot down so that you can research them later. And in addition, as I said, I'm going to be giving you some homework. So you're going to want to write things down. I want to start, even though what's special about our talk tonight is the halacha, I want to start the lecture talking about secular law. And the reason that I'm doing that is that if I were to jump in directly and explain to you how the halacha works regarding wills, I think you would get lost very quickly. Because in order to understand the chiddush of the halacha, in order to understand how the Torah sees inheritance, you have to first have a context, how a normal, modern legal system understands how wills work. And then when you understand that in its basics, then you will be able to appreciate the problems that exist in halacha, and you'll be able to appreciate the solutions that we've created. So let's define a will. A will is very simple. A will is a piece of paper in which you have written down your wishes for what happens after your death regarding two main issues. And they are what we call your assets, which is a fancy word for your property, all the stuff that you own, which after you pass away is called your estate. All those words, my property, my estate, my assets, it's all basically the same thing. And the other issue, the main issue that you can talk about, you can write about in your will, is guardianship for your minor children. There are other minor issues which you can address in a will, such as you can talk about where you want to be buried. I don't want to leave Eretz Yisrael. I want to be buried in Eretz Yisrael. Hespedim, your tombstone. And you can write what is called an ethical will to your children, to your family, in which you try and tell them things that you feel are important about life. An ethical will, for example, the famous Igeret HaRamban was an ethical will. And there are many, many poskim who actively encourage people to write ethical wills, and either to put them in their normal will or to write it as a separate document. But basically, we are talking about your money and your minor children. There's a common misconception that there are certain things in a will that really don't belong there, and they have no place there. And you cannot control them from a will. And that is anything which has to do with things that happen in your lifetime. A will is simply a piece of paper which sits in a drawer, hopefully for decades, ad mea v'esrim, and it in no way influences the running of your life. And therefore, things which might happen during your lifetime are totally irrelevant to a will. For example, if you want to give tzedakah in your lifetime, if you want to set up a trust, if you want to create what's called a durable power of attorney to give people power to do things in your lifetime. And a durable power of attorney is also called a continuing power of attorney or an enduring power of attorney. It's all the same thing. Or if you want to create medical proxies, or you want to make what's called a living will, all those things have nothing to do with making a will. That's a different lecture. It's a different legal service. It's a different document, and we're not going to be talking about them tonight. Therefore, what we can say is that a will is a document which never stands alone. The will is a culmination of a process which we call estate planning. Estate planning means we meet with you, we ask who you are, who are your children, who are the people that you want to benefit, what's your community like, where do you want your family to be, how do you see your family in the future, how do you want to take your personal assets and give them to your children, or the people who receive money from your will, who are called beneficiaries, and what's your vision for them? All that other stuff you can't do in the will. but that's also things that we can talk about. But the will comes at the end. We have one of the questions that I always tell Yaakov, one of the things that aggravates me more than anything else is when I get a phone call from somebody who wants to make a will, and the first thing they ask me is, how much does the will cost? Like that's the most important thing you have to think about. Like there are so many important and vital issues that you have to confront. That's really not the first question to ask. Now, when a person has a will and he passes away, that will in and of itself still means nothing. It's still a piece of paper. That will has to be brought to a probate court, which is a court which verifies the power of the will. It verifies that the will is legitimate, that it was really written by the person who wrote it, that there are no objections to the will, that there are no flaws in the will. Here in Israel, you bring a will to the family court, or you can bring it to the rabbinic court, to the Beit Din Rabbani, and they will give it the power of a probate order, which in Hebrew is called a tzav kiyum tzava'ah. If you don't have a tzav kiyum tzava'ah, the will is worthless. You can take the will to the bank, you can take the will to Tabu, which is the Israeli land registry, and they'll look at the will and they say, that's a very nice will, but until you bring us a probate order, we're not going to touch the will. We have nothing to do with your will. And this is the same in the United States. If you don't probate the will, you haven't done anything. And therefore, it's very important that you make sure ahead of time that the will fulfills the conditions that the probate judge is going to be looking for. In other words, if you try and write a will on your own, it is possible to write a will on your own. It's legally allowed, and there are some people who do it, but you're taking a chance that you don't know all the bells and whistles, you don't know all the hoops, and if you make an error on your own, by the time after you've passed away and they show it to somebody, it's going to be too late. You're not going to be around. It's not like a contract. If two parties make a contract and they goof up and they realize that they wrote something that's incorrect or they forgot something, as long as they agree, they can rewrite the contract. You can't rewrite a will after you've gone. That's it. You have one chance or many chances before you pass away. So writing a will really it's a big risk. You're trying to anticipate everything that you need to anticipate. You're trying to get it all done. You're trying to get it right. And Baruch Hashem, if you do it correctly, you are saving a lot of heartache for your beneficiaries. You start saving a lot of heartache for your family, because you will have shown them, I took into account all of this. I understand. This is what I want, and I want you to understand that this is the way I want it to be. And people will not say, well, Ima would have wanted it this way and Abba would have wanted it that way. No, there's no argument about what they would have wanted, because we know what they want. So the main subject that we have to talk about is money. But before we talk about money, I want to talk about, for about 5 minutes, the other big issue that you can address in the will, which is guardianship. Now, for those of you for all your children have grown up and they're all over the age of 18, it's not really relevant for you, but you can listen. But if you didn't get a cup of coffee before this began, this is the time to run to the kitchen and grab a coffee, because it's not really relevant to you. But if you have children who are minors, who are under the age of 18, do not run to the kitchen right now, because this is very, very important, what I'm about to say. When a child is born, he automatically has what the law calls two natural guardians. His natural guardians are his parents. And you don't have to go to the Misrad Pnim to be a natural guardian. You don't have to get a card from anybody. You don't have to get permission from anybody. The law in all jurisdictions says that a child's parents are his natural guardians, and they're responsible. They have the right to raise him and to make decisions for him until he reaches the age of 18. Once he reaches the age of 18, it's all over, and he has full autonomy. Now, if something should happen, chas v'shalom, to one of the two parents, nothing in terms of guardianship really changes. It's a major trauma to the family, to the spouse, and to the children. But in terms of guardianship, nothing changes. And according to the law, you don't need two guardians. A child needs only one guardian. And many children might lose one parent while they are minors, and they reach the age of 18, and the other parent took care of them, and everything's fine. The crisis is, and this is what we have to address in the will, what happens, chas v'shalom, if before the age of 18, both parents go? And this can be simultaneous, but it doesn't necessarily have to be simultaneous. It could be at two entirely different points in time. When that happens, the child's guardianship returns to the state of Israel, or to the United States of America, in the case of America. And the child's future is handed over to a judge who has the extremely unpleasant task of deciding, what am I going to do with this kid? How did his parents want him to be raised? What type of school is he going to go to? Who's going to feed him? Who's going to take care of him? Who is going to make parental decisions that a parent normally would make? And the judge is not going to do that. He has to find a guardian quickly, and he has to appoint a guardian. Now, if you don't write a will, or if you don't address this issue in the will that you wrote, everything's open. The judge is going to have to use his common sense. There's going to be a lawyer from the Justice Ministry sticking his nose into the family's business, trying to decide what he thinks is best for the child. And therefore, it's very, very important that I always impress on my clients who have minor children, you have to address this issue when you're writing the will. Do not skip over it. And I want to give you something that happened to me at one of our lectures that I think drives home this point, and it drives home the point in a special way for Shapell alumni, or at least some of them. About 10 years ago, Yaakov and I gave this very same lecture to the Gerin Torani in Lod, in Hebrew. And after the lecture, this woman came up to me, and she said to me, she started talking to me, and she had a funny accent in Hebrew, which I couldn't identify. And she said to me, my husband and I, we have no money whatsoever. We live in a rented apartment. We really don't have any money, but I'm so glad that I came to your lecture because I realized that I have to make a will. And I said, really, why is that? And she said to me, listen, my husband and I are Gary Tzedek from the Netherlands. All our next of kin are Goyim. And I realized from your lecture that if chas v'shalom something would happen to both my husband and myself, the court is going to summon the next of kin to take my children, and my father and my mother, or his father and his mother, or our brothers and sisters are going to take our children out of Israel. They're going to bring them back to the Netherlands, and they're going to raise them as goyim. And that, for me, is absolutely the worst possible thing that can happen in the world. So I realized I have to find somebody that I can appoint who is willing to be my guardian of my children, and that will raise them in the way that I want them to be raised. Now, not everybody is a non-Jew whose family are non-Jews, but there are a lot of Bali Tshuva who are listening to this conversation. And ask yourselves, if chas v'shalom something should happen to you and your spouse, where are your children going to go? Are they going to go to your brother and your sister back in America who might not be religious? Are they going to go to your brother and sister who might be in Israel, but they're not going to raise your children the way you want them to be raised? This is a real crisis, and it can happen, and it does happen. So this is a big reason why you must address this issue in a will and why you must make a will. The next issue that I want to talk about before we talk about what's in a will is the question of intestate inheritance. And here's the word that we have to define. What does intestate mean? I think all of you know that the legal term for a will is not just a will. We call it a last will and testament. And that is because much legal English draws from two phonetic sources. It draws from the German, it draws from the Latin. So we call it a will because it comes from wollen in German. And it's called a testament, which is the word in Latin. So if you have a testament, that means you have a will. If you die intestate, that means you died without a will, that is the boogeyman for us. That is the situation that we are trying to avoid at all costs. Intestate in the same way that something is coherent and something is incoherent. So if you die with a will, you die testate, and if you die without a will, you die intestate. Now, the state of Israel and the United States of America, every one of the 50 states of the United States of America has an intestate default distribution of your wealth. In other words, if you die, nobody starts scratching their head saying, well, gee, what are we going to do with this guy's money? There is every single jurisdiction, including the state of Israel. And as I said, every single one of the 50 states, the United States of America, has an intestate description of what happens to your money if you don't write a will. Donna, this is the point that if you could put up slide number 1, we'll take a look at it together. Okay, so look at chart number 1 at the top. Can you make that big, just chart number 1 itself? Okay, take a look what we've got here. This is a flow chart which describes what happens. This is Sifa Chadashei Chokei Yerusha, section 11 of the Israeli Chokei Yerusha. This is the intestate order. If a husband or wife dies, it doesn't matter whether it's the husband or the wife. It's totally equal. The surviving spouse on the left gets all the tangible physical property. They get the car, they get the furniture, they get the housewares, they get everything else. Okay? 50% of everything else, which includes the real estate and the bank accounts and all the money, go to whatever children there are. And on the right, you will see that those children, whether it's 1 kid, 2 kids, 3 kids, 7 kids, they divide that remaining 50% in equal portions. All children, boys and girls, inherit equally. There's no distinction. There's no distinction for adopted children as opposed to natural children, boys, girls. Everybody inherits equally. Now, if you think about what happens when, let's say, the main breadwinner of a family dies, I hope you understand the crisis this created, because that means that the mother, let's say it's the father is the main breadwinner in the family. And the mother now has to run the household, but she doesn't even own 50% of all the money. 50% of the money is now owned by children. And children, if they're minors, they're not allowed to do anything with that money, which means every time she needs to dip into the family savings to do something that she needs more than just 50%, she's going to have to go get a court order because the children are not allowed to make dispositions. Okay? So this intestate order is very, very important. You have to understand, it is there all the time. Even if you write a will, it is lurking in the background, waiting to reinstate itself. The state of Israel and the United States, they're totally parve on the question, do you write a will or don't you write a will? What they say is, this is the intestate order. We're making it available. This is the solution that the law provides. If you don't move off the default, if you do not write a will, this is going to control your family's destiny. And it can cause tremendous hardships for people. It exists because if there was nothing, the situation would be even worse. But I think if you look at this, I think you can understand that if you're the surviving spouse, this situation is going to be very, very difficult for you to regulate. Now, if a person decides intentionally not to write a will, this is what's going to happen to his money, to his estate. If it can also be unintentional, because, for example, let's say you wrote a will, but it got lost, it got destroyed, it got misplaced, or the deceased wrote a will, but it was invalidated by the probate court when it got to the probate stage because there was something wrong with the will. Okay? So this is what we're trying to avoid. We don't want to be in this situation of having this intestate regime govern our family. Now, Don, if you could show chart number 2. What you're looking at here, this is the classic will that we write for 80% of our couples, and what not just us, but I think almost all families, this is what we're looking for. On the first level, we're looking that when either the wife or husband passes away, chas v'shalom, then the entire estate passes to the surviving spouse. Only on the second level, when the second spouse has passed away, do we move down to the second level and it's distributed among the children. Ostensibly, it's equally, if it's 3 children, 3 portions. If it's 4 children, it's 4 portions. If it's 5, et cetera, et cetera, et cetera. That is what we normally That's what we normally see. In order to move off chart number 1 and to get into chart number 2, you have to write a will. It's never going to happen if you don't write a will. Now, I just want to explain for a few minutes the severity, the financial severity, the financial hardships that happen to a family if you don't have a will. What happens is the following, is that minor children become owners in fractions of the family wealth, which means they're going to own part of their father's bank account. They're going to own part of let's say if the father passes away, they're going to own part of his personal wealth. The mother is not going to be able to manage the family as she normally would, because part of the money is owned, 50% of it is owned by children. And if those children are little children, she's in a very, very difficult situation. Now, minors cannot inherit. They can inherit. A minor can inherit, but he cannot dispose. In other words, he can't spend money. A minor cannot spend money. If, for example, just to give a simple example, if you own a house, and let's say a person owns a house 50-50 with his wife. So that means that if he passes away, his 50% is going to be divided up among his family. Half of his half, 25%, is going to go to his wife. She will now own 75%. And the other 25% is going to be owned by the child. That doesn't help anybody. That's a very, very bad situation. A child cannot sell the house. If the wife says, this house is too big for us, we can't afford this anymore, we're going to buy a smaller house. We're going to sell this house. She won't be able to sell the house. She'll need a special court order, which will empower the children to sell their portions of the house. It's a terrible situation, and nobody should ever should reach the situation. But this is what happens if you die intestate without a will, because your children are going to inherit large fractions of your personal wealth. Now, one of the common misconceptions that people have regarding wills is that you can write a will and you can basically dispose of all of your wealth by writing the will. And this is a misconception which is not at all true. And in fact, in certain cases, it might not even be true for even the majority of your wealth. And that is because there are certain properties which are owned and their disposition is not governed by the will. Donna, can you put up the slide regarding joint tenancy and the other things? Okay, look at that acronym, that Rashi Tevos, JTWROS, joint tenancy with right of survivorship. This is a term which is peculiar to American law. It does not exist in Israel. Joint tenancy with right of survivorship is the de rigueur default way in which people in the United States, couples in the United States, own the real estate and in which they own their bank accounts. Joint tenancy with right of survivorship says that two people own something together. When one of them passes away, chas v'shalom, all the surviving spouse needs to do is to present the death certificate to the bank or to the deed company who has the title who registers the title to the real estate, and the entire property will be registered in the name of the surviving spouse. Joint tenancy with right of survivorship. This is very convenient because you don't have to go through probate in order to take possession of the full 100% value of the property. This concept of joint tenancy does not exist in Israel. Israeli law does not recognize it. And this is one of the major differences between the United States and Israel when we plan estates, is that we have to take into account that in Israel, there is no joint tenancy, which means, yes, if you remember what I said a few minutes ago about small children, that means that if you do not write a will and you die intestate, one of the spouses dies intestate, fractions of his ownership of the family home are going to go to minor children or to older children. And the surviving spouse will not even own anything more than the 50% that they had. And that can be a real crisis. Now, this type of property is not governed by a will. There are also other types of properties which are usually financial instruments, which are called, if you see what's on the screen, TOD and POD, which means transfer on death or pay on death. And you can see in the little letters next to what that means is the transfer of the title will be transferred according to somebody that you have designated, or you have given an order that it will be cashed out to that person. These type of instruments, and it is quite possible that the majority of a person's wealth might be invested in these type of properties. It doesn't even go through the will. It will be taken care of by what's registered in the company or the financial institution which is administering these assets. Therefore, it's very, very important to understand that if you have a number of financial instruments, if you have a life insurance policy, if you have what's called in Israel a Keren Hishtalmut, what's called a Keren Pensia, these things normally are not governed by your will. You have to set up in your lifetime who are the designated beneficiaries. You have to do this because the will not govern these things normally. Okay, now, in addition, I will mention, by the way, that joint tenancy is the default in the United States of America for real estate and for bank accounts. However, in 2 states in the United States, it is not. And those states are, drumroll, Louisiana and the state of Texas. So if any of you live and have property in the states of Louisiana and Texas, you should be aware that your situation is the same situation as Israel. There is no joint tenancy. And therefore, a spouse, if one of the spouses passes away, chas v'shalom, the other 50% is not going to go straight to the surviving spouse. It's going to go partially to him and partially to the other children. Okay? Now, the 4th term there is a beneficiary designation. Beneficiary designation is a general term. A TOD and a POD are both types of beneficiary designation. And in fact, joint tenancy is also a type of beneficiary designation. But when we use the term beneficiary designation, we use that to describe situations in which you can designate who is supposed to get your money after you pass away. Normally, what you do is you designate your spouse as the first level. And if you outlive the spouse, then it will go to your children. And you can designate it, go in equal portions to your children. You can designate certain children. That's all up to your discretion. So what you have to understand, the takeaway from this is that don't assume that this just by writing a will, you've solved the problem. Because all of these institutions will tell you, we don't want to see your will. We don't look at your will. We're not allowed to look at your will. You have to have made beneficiary designations. And here's the bad part. If you do not make beneficiary designations in your lifetime, that asset is usually deemed to be intestate. Now, there's that boogeyman that we're trying to avoid. You can fall right into that trap. You can write the best will in the world with the most details and an exact description of what you want. But if you don't take care of all of your joint tenancies and all of your PODs and all of your TODs and all of your assets, which require a beneficiary designation, and you write there what you want, then you're going to find yourself in a situation where they're going to say, we're not going to release this money until you go to probate court and get an intestate succession order telling us what to do with the money, because we're not working according to the will. We are not subject to the will. We are not obligated to the will that you've written. Okay, and this is homework assignment number 1 for all of you. Homework assignment number 1 is make a list of all the financial assets that you have, and I mean everything. I'm talking about your Karnot Hishtamut, I'm talking about your pensiot, I'm talking about joint bank accounts, I'm talking about your IRAs, I'm talking about any financial instrument. Contact them. You can do this by email with them, and you can say, have I ever designated my beneficiaries for you? And they'll take a look and they'll tell you, no, you never have. And they'll give you a form and they'll say, here's a form, fill out this form, tell us who you want, and we'll write it in. And it's very simple. You fill out a form, you probably can even write it out in handwriting. You fax it back in or you scan it and send it by email, and you're all set. And they say, okay, we now have on record your will. We have on record what your desire is as to what is to be done with this money. And you can change those things over the course of time. But if you don't do that, and you might have 16 of these things, and if you do 15 and you don't do it to the 16th, they don't care what you did on the other 15. They're going to say, you didn't write us. We deem this asset as intestate. You're going to have to go to court and get us a court order telling us what to do with this money. And that's a situation that you're trying to avoid. Okay? Homework assignment number 2 for Israelis. Since Israel does not have joint tenancy, there are 2 things that you have to look out for. First of all, you have to contact your bank and you have to ask them, how is our account set up? And they will tell you it is not set up as joint tenancy. It's a different type of joint ownership. You have to ask them to give you a form which is called Sif Arichut Yamim, which is a long life Sif, which is basically it approximates, but is not congruent to the American joint tenancy. It will allow the surviving spouse to use the bank account for a certain period of time after the spouse has passed away, but it's limited. It's not the same thing. I can't go into the details of why it's not congruent to joint tenancy, but it is something that exists in Israeli law. You don't necessarily have it. You have to ask them, did I ever sign a Seif Arichut Yamim? And they'll tell you whether they have it on record or not. Okay? Now, the last term is the general term that I want to talk about, and I've already mentioned it. Let's talk about its implications. Beneficiary designations. As I said before, the previous 3 are special types of beneficiary designations, but there are assets in which that you can make a beneficiary designation. This is true in the United States. It's true in Israel. Almost all of your savings plans, your IRAs, insurance policies, all of these things give you the opportunity to make beneficiary designations. Sometimes, and this is something you also have to check, sometimes the financial institution does not allow you to make a 2-tier beneficiary designation, meaning they'll only allow you to give it to your spouse. They won't allow you to say, and if my spouse is not alive, then I want to go to my children. They don't always allow that. You have to check, and you have to find out what they allow and what they don't allow. Now, Donna, could you put up the section 147 on the screen for a second? Okay. All of you are now going to go to Israeli law school for 30 seconds. This is section 147 of the Israeli succession law, the Choka Yerusha Yisraeli. I'm going to read in Hebrew, and then I'm going to read it in the translation. This is my free translation, and then we're going to discuss what it means. סכומים שיש לשלם עקב מותו של אדם, על פי חוזה ביטוח, על פי חברות בקופת קצבה, או בקופת תגמולים, או על פי עילה דומה, אינם בכלל עיזבון. זולת, אם הותנה שהם מגיעים לעיזבון. In English, payments which fall due upon the death of a person as per an insurance policy, membership in a pension fund or savings fund or similar arrangement are not part of the estate. Unless it was stipulated that they belong to the estate. Now, what this means is that you can control your estate by writing a will. But if we have decided, if the law has defined for us that these financial instruments are not part of your estate, then nothing you can write in your will is ever going to save these assets from going to the people you want them to go to. These institutions will say, I'm sorry, you never designated somebody. These are intestate. We do not recognize the will. You're going to have to go to court to tell us what to do with that money. And the money is going to go, who's the money going to go to? You guessed it. It's going to go in fractions to your minor children. Half will go to your wife. The other half is going to go to your children. And once again, you're going to be stuck needing money that you cannot access because it belongs to minor children. Okay, so this homework is really very, very important. Do not, under any circumstance, leave any financial asset that you can designate beneficiaries undesignated. It's dangerous. It's not a good situation. Okay? A special note for Israelis. Those of you who have made Aliyah, you should be aware that most American financial institutions that I have come across do not allow you to make beneficiary designations once you've left the United States. In other words, if they know that you are in Israel, they will not allow you to make beneficiary designations. If you still have a mailing address in the United States and they don't know, you can get away with it. But if they find out that you have left the United States, they are liable to say to you, we will not recognize any beneficiary designations because you've left the United States. So, lesson for all of you expatriate Americans who live in Israel who might have IRAs and savings plans and life insurance policies, et cetera, in the United States. Check out, do you have beneficiary designations? Do you not have beneficiary designations? Is there some way for you, even though you're living in Israel, to fix that and have it registered? At the very least, even if you don't put in all your children's names, write something like, as per my will. Because if you write as per my will, then you removed it from the intestate regime, and you'll probably have to probate your will in the United States to get that money. But at least you get the money according to the will. If you don't do that, they're going to say to you, I'm sorry, this is an intestate asset. You must go to court to free up this asset. Okay? So, homework assignment for everybody, Israelis and Americans, make a list of all of your assets. And here's something special for the Israelis to do. If you don't know about it, in the website of the Misrad HaOtzar, the finance ministry, there's a special sub-website which is called Har HaKesef, the Mountain of Money. And on that website, it's a secured website. You can put in your name and your Israeli Tudat Zehut, and they will give you a list, an exhaustive list of all of the financial institutions in the state of Israel which are holding your money. And you might be very pleasantly surprised there to find that there's money waiting for you that's being saved that you forgot about. Like if you had a job for a certain period of time and then you moved on and you forgot about it. It could be that they put away money for you and you don't even know it. Last month I got a letter from one of these institutions. A long time ago, 30 years ago, an employer took off money from me. There wasn't a lot of money. It was 1,500 shekel. But it's my money. And I had totally forgotten about it. I didn't know about it. And I got this letter out of the blue saying, this is your money. Come and get it. Okay? But this is something you need to do. This is the type of thing that is commonly neglected, and it should not be neglected. Let me give you a common scenario. You either the worst would be that you didn't ever make any beneficiary designations. Another option is that you made a beneficiary designation and you designated, let's say, your spouse, but you've had children since then. Now, you don't want to leave that way. You want to add the children as a second tier. Often it happens that people they get a job, they get one of these types of chronot, and they put it in the name of their wife and their 2 kids. But Baruch Hashem, they don't have 2 kids anymore. They have 7 kids. Now, if something's going to happen to you, that money is not going to go to the 7 kids. It's only going to go to the first 2 kids who appear there. So you really got to go contact each of them. And by the way, this is something you can do online. Every respectable financial institution has a designated beneficiary form. They have an entire department. Their whole job is to accept and register these pieces of paper. You can find it online. Just look them up. Look up beneficiary designations. If it's in Hebrew, they're called mutavim. And you can get all your ducks in a row. It doesn't cost anything. You don't need a lawyer to do it, and a lawyer shouldn't do it for you. You really need to do this on your own. Okay? Now, I will say, in leaving the subject of beneficiary designations, it is quite possible, and I see it, that the vast majority of a person's wealth can be deposited in assets like this. and they barely need a will, because almost everything, if their real estate is in joint tenancy in the United States, if the majority of their assets, their financial assets, are being saved in institutions like this, a very small amount of the money is going to be governed by the will. So what can we say about the will? I am going to leave to Yaakov to talk about the contents of the will, but I want to make a few points. Number one, the Rambam in Hilchot Nachalot recommends not to discriminate between your children. And he mentions the story of Yosef and his brothers, and he says, discriminating between your children is not a good idea. You have to have a really good reason to do that. Try not to discriminate between your children. Point number two, disinheriting. I don't know why this is happening, but my clients are beginning to ask us about disinheriting children in ways that they never asked us before. You should be aware that in the United States, it's very, very difficult to disinherit a spouse or disinherit a child. There has to be a good reason, and it's subject theoretically to the intervention of the court. You should know that disinheriting is very frowned upon in Halacha. It is not considered a good thing to do. There are many, many Rabbanim who actively discourage it, even if, and listen to this, even if the child has left the fold in your estimation, if he's no longer he doesn't live the lifestyle that you want him to live, most Rabbanim say you should not be doing this. You should not be disinheriting a child. This is something that you need to consult a competent Rav with. I came across on the internet, from preparing for this lecture, an excellent article by a Rav Ephraim Goldberg. Ephraim, I don't know who he is, but he had an article about disinheriting in Halacha. I suggest that you seek it out on Google and take a look at it. It is very, 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 very good. Another thing to think about is giving tzedakah. The Chafetz Chaim and Avas Chesed and many, many other Rabbanim and Poskim talk about the idea of taking a certain portion of your wealth and giving it to tzedakah. In general, you should make no oral representations to your children about what's the contents of the will. That can create machlokas and resentment already in your lifetime. What you should say to the children is, you should know that we have made wills and we've taken care of everybody, and it's all organized. And when the time comes, you'll find out what's there. But there's no real reason for your children to know what you've given them in the will. Another thing which we really advocate that you put into the will a recommended posek, a recommended rav. There are questions that can arise during the administration of a will. There might be questions that will arise about the contents of the will. And if you designate who the rav is going to be, then you've made things a lot easier for yourselves. Okay? So to summarize the secular will, and as we're finishing and moving into halachic wills. So your goal in writing writing a will is to remove yourself from that boogeyman, the intestate regime of inheritance. You want to replace that with a tailor-made vision that reflects your family, reflects your values, that reflects the amount of money that you have. My partner Yaakov Greiff, in his lecture, he will talk about more of the nuts and bolts of what that secular will look like, and addressing some of the particular problems of Israeli Americans. In parting, I want to make two observations. If I compare, and this is something that didn't strike me until years and years of doing this. If I look from a bird's eye view at American estate planning, and I look at Israeli estate planning, we're actually heading in two opposite directions. Really, why? Because in America, we're trying to watch out for probate. Probate is the boogeyman. We're trying to give everything a beneficiary designation. We're trying to put everything into joint tenancy. Maybe we're going to put things into a trust. We're going to try and avoid probate, because a probate in the United States means money. It means you have to pay for probate. There might also be estate taxes, which Yaakov is going to talk about. And it's a process which is a bureaucracy which takes minimum amounts of time. Okay? Israeli probate is precisely the opposite. You can probate a will in the state of Israel for less than 1,000 shekel, which is like what? That's like $300. Okay, you might pay a lawyer to that for that. That's a few more $100. It takes 2 or 3 months. There are no estate taxes in Israel. So there's nobody's coming to take away your money. So I mean, it's really comical. Sometimes I see American wills. Last year I got an American will which was 35 pages long. 35 pages. 2 pages was an actual will, and the other 33 pages was setting up an elaborate trust to avoid the taxation of the estate. 33 out of 35 pages was tax planning. It wasn't estate planning. In Israel, that will could have been 2 pages. Okay, so that we don't have to worry about the boogeyman of probate here in Israel. Probate it's a routine thing. Unless somebody opposes the will, and nobody should, it goes through, you have to wait a few weeks, and it goes through. It's really no problem. So if we have Israeli Americans who have property in the United States and in Israel, we're going in opposite directions. On the one hand, all of their Israeli stuff we're trying to put into Israeli probate, and make sure that everything is going to go through nicely and quickly, and all their American stuff we're planning that will never go to probate. Right, so we're heading in two different directions, and Yaakov will speak about how that's done. Now, last comment I want to make regarding secular law, and this is our threshold to move into talk about halacha. Both Israeli and American law and any secular jurisdiction is totally indifferent to the question: do you make a will or don't you make a will? They don't care. They say, if you don't want to make a will, no problem. We have the intestate order waiting and ready for you, and you saw that in the chart. If you want to make a will, then you can do whatever you want. But we have certain rules about what the will has to look like and how you do it. But in general, you can give your money away as you like. Okay? But they're indifferent. They're totally parv. It's not like if you go to a judge and you didn't write a will, the judge is not going to say to your survivors, "Oh, no, this guy didn't make a will. That's a terrible." No, he doesn't care. It's totally indifferent. We are going to see, and I want you to keep that in mind, because we are going to see that the halacha does not work like that. The halacha does not deem the intestate order of the Torah as being something that's available, and if you want it, take it, and if you don't want it, you can ignore it. That's not the way the Torah looks at the intestate order, okay? So with that, let's move into talking about the Torah's view of inheritance, okay? Now, Donna, if you could put up chart number 3. Okay. Take a look. I want to let your eyes settle on this give you like 5 seconds, and then I'll start talking about it. Okay, the first thing you notice is that if the husband or the wife dies first, it's a totally different order. It makes a big difference who dies first. Let's look on the left. If the father dies first, the wife is not an inheritor. She is disinherited. According to Din Torah, she inherits nothing. She becomes the main creditor of the estate, and we're going to talk about what that means briefly. But in principle, she does not inherit anything. All of the sons inherit in equal portions. If there is a Bechor, meaning a firstborn male, and we will talk soon about what are the conditions, what defines halachically a Bechor. If there is a Bechor, he is going to get a double portion. If you see there, the Bechor, like his box is like a little bit, it's not 2 times as big, but it's bigger than the box of the other sons. There is a Bechor, and normal sons, they're called Pshutim in halacha. There's the Bechor and they're Pshutim. They're Banim Pshutim. Okay, the daughters, they're also in a white box. The daughters are totally disinherited. The daughters get nothing, 0. Okay, in addition, adopted children do not inherit. According to the halacha, if you adopt a child, it's a tremendous chesed. But by pi halacha, your adopted children do not inherit. Okay, We will talk about what happens to daughters and adopted children further on, but this is the strict Torah regime for inheritance intestate, meaning if you don't write a will, this is what's going to happen. Look on the right side now for the wife. If the wife dies first, then everything goes to the husband, 100%. He doesn't have to do anything. And if he goes, then once again, it will go to the Bechor and to the sons. And once again, daughters are totally disinherited and adopted children are disinherited. So, Dada, could you put now 2 and 3 together? Okay. So on the top of chart number 2, you have what is the typical, what 80% of our clients want. This is a normal family that doesn't have any second marriages, any divorces, no Brady Bunch situations. This is what people normally want. So look at how different that is from the intestate order of the Torah. So the question is, if that's the intestate order of the Torah, how do I move off that intestate order and reach a will like I want? And the other thing that you have to consider is the following, is that that intestate order is very, very different than the secular intestate order, which is in chart number 1. We're not going to bring the chart number 1 back in, but you remember what it looked like. It's totally different things. What that means is the following. If you do not write a will, okay? If you do not write a will, and you do not make a halachically valid, then what happens is your property is going to be disposed either by the state of Israel or by one of the 50 United States, and the money is going to go to all types of people who aren't supposed to be inheriting you, in proportions that they're not supposed to be inheriting you. And you're going to be violating Din Torah because, number one, you're not distributing according to Din Torah, and number two, you're not distributing according to a will that was halakhically valid because you never wrote a will. So even if a person would come to me and say, I really like this idea of the Din Torah. I want all my money to go to my sons. I don't want any money to go to my wife. Well, if you like that so much, then you have to write a will that sets up the Din Torah inheritance, because it's not going to go that way, because the state of Israel will not recognize the Din Torah inheritance, and the United States will not recognize the Din Torah inheritance. You have to write a will to move off the default of the intestate inheritance. Okay, so how do we get to a will? How is it that we write a will? If you think about it, there's nothing mentioned in the Torah about writing a will. There are certain there are certain subjects in the Torah which have extensive details. In Parshat Matot, we have an entire parak which talks about Nadarim. In Parshat Tazria Matzor, we have an entire parsha which talks about Negaim. But nowhere in the Torah is there such a systematic description of what happens in inheritance according to Din Torah. There are 2 portions in the Torah from which we learn about inheritance. The most famous one is Benot Slavchad in Parshat Pinchas, which talks about what happens when a man dies without sons. And it describes that his daughters can inherit him if there are no sons. And at the same time, the Torah goes through certain levels of inheritance to explain what happens. The other place that we learn about inheritance is from the parsha of the Ben Hasnua. If you remember Parsha Ki Tetzei, there's the famous story that a man has a son of the hated wife, or she isn't really hated. She's the not preferred wife, and there's a son of the preferred wife, right? And it says there in the Torah, 2 psukim, which I'm going to read out to you. I should have made a slide for it, but I didn't. V'haya b'yom hanchilot banav et asher yelo. Lo yuchal levaker et ben ha'ava al pnei haben hasnua habachor. Ki et habachor ben hasnua yakir letet lo pishnayim mikol asher yimatzeh lo ki hu reshit ono lo mishpat bechora. In other words, even though he doesn't prefer the eldest son of his not preferred wife, that is his Bechor. And he has to give that Bechor a double portion. Now, from the lead up, from the beginning of that pasuk where it says, "V'haya b'yom hanchilo et banav et asher lo yuchal levaker ben ha'ava," the Gemara in Baba Basra learns that there is such a thing as the person having a certain amount of discretion in distributing his estate. Because when it says, v'haya b'yom hanchilo et banav, all the Torah says is that he can't prefer the Bechor of the preferred wife to the Bechor of the non-preferred wife. But there are other things that he is allowed to do. And from there, the Gemara has a very extensive discussion, which we cannot summarize. But basically, to put it in a nutshell, a person is allowed to dispose of his assets in his lifetime before he dies, provided he does not call it a Yerusha. You cannot call giving things to people who are not your legal heirs according to the Halacha. You cannot be morish them. You cannot use that lashon. And we in our wills that we write in the office, we avoid using that term. We do not use that term. And in English, we do not use the term bequeath, which is probably the word you probably heard. We do not use that word. We avoid using that word at all costs. But we still have to give a preferred status to the Bechor. I want to read to you something that the Rambam says in Hilchos Nachalos, which is what he calls his laws of Yerusha. The Rambam says the following thing: Ein adam yochol lahorish mi she'eino ru'ui liyorsho. A person cannot give as an inheritance something to a person who is not his legal heir. V'lo yakor Lo la'kor ha'yerusha min ha'yoresh, nor can he take away the Yerusha from a person who is entitled to be a Yoresh. Afal pisha zeh mamonhu, even though it's his own money. L'fisha ne'amar b'parshat Nachalot, because it says in the parsha of Benot Tzlofchad at the end, V'haita livnei Yisrael lechukat mishpat. It is a chukat mishpat to the Jewish people. Lomar shechukazo. Lo tishtane ve'in atnai mo'il ba, ben shitziva, ben shubari, ben shchimira, ben balpeh, ben bechtav, eno mo'il. You cannot bequeath to somebody orally or in writing, whether you're healthy or whether you're on your deathbed. You cannot deviate from the Torah's regime. So, if so, we have a bit of a difficulty now. Because how is it that we're writing wills that's exactly what we're doing? In the lifetime, we are disposing of things not necessarily in the order. Because if we are ostensibly giving to all of our children equally, that means we have raised our daughters who are not halachic heirs, we have raised them to the status of the sons. And not only that, but even before the sons inherit something, the man is giving everything to his wife. So how is that possible? Okay, so I'm jumping ahead a little bit here, but I don't want to leave you hanging. The main solution that we use when writing a will to make it halachically valid is that all of the normal provisions of a will, we are turning them into what's called a shtar matana, a gift deed, in which the testator, which we've learned the testator is the person who's passing away and writing the will, he is gifting all of what he wants to gift to his wife, and after her, to his sons and his daughters. Okay? Now, there are many wills that are out there that have been written by Rabbanim. It's a common thing. It's commonly done. But what you have to understand is there is a way to do it, and there is a wrong way to do it. And if you don't have a will which is drafted by a competent lawyer who knows the halachas, or by a lawyer and it has been supervised by a competent Rav who knows these laws, you can end up writing a will which basically the poskim say can bring you to Geza. You can be causing a situation where people who are not inheriting halachically are stealing money from the halachic heirs. and you're putting them in a situation that then they might not even understand or know that this is forbidden. But that's what you might be doing. So you have to have a will that works properly, and it has to be validated halachically. Okay? And we've already seen how much worse it can be if you don't write a will at all. So I will also mention, practically speaking, for those of you in Israel, the rabbinic courts are very, very aware of this problem. And they do not step on landmines. Okay, if you come to a rabbinic court, and let's say your father never made a will, and you as a family go to the rabbinic court, and the daughters want to get their share, and the sons want to say, well, this is a Beit Din Rabbani. We like to inherit according to the halacha. We want all the money to go to us, and we don't want any of the money to go to the daughters. The Beit Din Rabbani is going to be in a crisis, and they're not going to touch the file, because they know that if they paskin according to the halacha and give to the sons and don't give to the wife and the daughters, then Bagatz is going to interfere, and they will nullify the psak. In addition, the judges themselves, the dayanim themselves, you should be aware, they are not so keen on this idea that we totally disenfranchise daughters. They understand it's a hard thing. They know, they see the cases before them where there's a tremendous machlokas, sometimes an irrevocable machlokas, which can go on for generations in a family. And therefore, what they do is they simply withdraw the case. They say, I'm very sorry, we can't handle this. You better go to a secular court and get them to sort this out. Okay? So we are in a situation where we cannot leave this problem unsolved. We have to write a will, and we have to write a halachic will. Okay? Now, before examining the three major issues and the three major solutions, I want to talk a little bit, I want to be a devil's advocate, as it were, against everything that I'm about to say. Because there is a very, very famous tshuva of Moshe Feinstein that a lot of people know about. And Moshe Feinstein was asked by somebody, a charity who received money from somebody who wrote a normal will, and there was nothing halachic about it. And they asked him, they said, look, we found out that this money was given to us by a non-halachic will. Are we allowed to take this money? So Rav Moshe wrote a tshuva, a very, very famous tshuva, which everybody who deals in this subject knows about this tshuva, in which he said, no, it's okay, because there is dina de malchusa dina. The law of the land is the law. And because this person wrote his will specifically subject to the knowledge that it was going to be probated in a secular court, you don't have to give back the money. Now, based upon that psak, there are people, I will say there are people who do not do anything about like the things that I'm about to suggest you that need to be done. In my opinion, and the opinion of almost all the poskim, that is incorrect. Rav Moshe is really, really in the minority on this issue. Almost all major poskim. I don't know. In fact, I don't know a single major posek who agrees with Rav Moshe on this issue. All of the poskim disagree with him, and they say, no, that can't be valid. Dina de malchusa dina cannot override the Torah's laws of inheritance. Something must be done. You have to do something to validate the will according to the Torah. Okay, so the assumption that our office works with, and the assumption that all the rabbanim that we work with, and all the poskim that we talk to, is that you cannot rely upon Rav Moshe's psak. And I spoke to a dayan here in Israel, and I asked him flat out. I said, in the Beit Din Rabbani, if somebody were to rely upon Rav Moshe's psak, what do you do? He said, we ignore it. We do not recognize Rav Moshe's psak here in the Beit Din in Israel. So, let's talk about the three major issues that we have, halachic issues, and the three solutions to them. I see that I've already gone over my time. I'm going to try and do this as quickly as possible, Yaakov. I'm sorry that I'm invading onto your time. The first problem is that according to the halacha, there is no such thing as writing a conventional will. Because what are you doing when you're writing a will? You're writing a legal document in which you're saying this document will not go into force until after I'm dead. Now, if you think about it, that doesn't make a heck of a lot of sense. And the halacha is very, very sensible. The halacha says there is no such thing as writing a document that will to go into force and you're going to make a kinyan that's going to be activated after you die. There's no such thing. How can you possibly do that? Okay? The second problem that we have with a conventional will is that once again we have the subject of the status of the woman. The wife does not inherit her husband, and the daughters do not inherit their father. Okay? This reflects a vision of the Torah that once upon a time in society, it was congruent with the way people lived. Women were considered dependent and supported by the men. Women did not have to work. They were part of the family unit. They were going to be supported by the family. And therefore, they also have special rights. When a person dies, according to the halacha, the wife can live in the family home until the day she dies. They can't throw her out unless she gets remarried. She's entitled to a stipend to live off of. The unmarried daughters are also entitled to a stipend. And in addition, when they get married, they're entitled to 10% of the estate as a dowry. Now, this society, this type of economic arrangement really it persisted in Western society until only about 200 years ago. If you were to look at colonial America before 1800 or England before 1800, that's what life was like. It only began to change in the Western world starting from the 1800s when women began to get rights to inherit and rights to own property. And that was called coverture. It's a word from the French. If you look up the word coverture, you can find entire articles about it. Okay, so I try to look at the old regime as reflecting something that was not oppressive and not necessarily totally incongruent with our values. Once upon a time, people lived by this, and they felt it was appropriate. However, we all know it's not the way that we live today. And therefore, the halacha had to find a solution to that situation. And I will point out that the solution that the halacha provided has nothing to do whatsoever with what we call modern feminism. Modern feminism is something that has existed, as I said, for less than 200 years. The solution in halacha that appears already in the Shulchan Aruch was created over 500 years ago, long before anybody talked about women's liberation, long before people talked about women's rights. Okay, I'm getting ahead a little bit on that problem. The third problem that we have to deal with is the double portion of the Bechor. The Torah prescribes that a Bechor has to get a double portion. Now, there are a lot of misconceptions regarding the double portion. For those people who don't have a Bechor, it's not really relevant to you. But I want to briefly run through some of the major points. First of all, the obligation to give a double portion to the Bechor is an obligation of the husband. It's not an obligation of the wife. In other words, a mother has no obligation to give a double portion to the firstborn son. Second of all, the laws of the Bechor for inheritance are not congruent with the laws of the Bechor of Pidyon Ben. Probably most of you know that in the Pidyon Ben, it has to be a Peterechim. It has to be a child whose birth opened the womb, which means if the woman had a C-section, then that did not open the womb, and that is not a Bechor. People also probably know that Pidyon Haben exists only for Yisrael. For Kohanim and Leviim, there is no Pidyon Haben. Okay? So in those 2 points, the halacha for the Bechor, for not what we call the Bechor leNachala, Bechor for inheritance is different. First of all, Kohanim and Leviim are subject to the same laws of Bechor leNachala as Yisrael is. Those families have to give a double portion to a Bechor. Secondly, a Bechor for Nachala, for inheritance, is not it doesn't depend upon petarechem. It does not depend upon opening the womb. And therefore, let me give you two simple examples. A woman is married to a man, and she has a firstborn son. And it fulfills all the halakhic requirements of a firstborn son. Baruch Hashem, there will be a pidyon ben. Okay? That son is also a bechor in terms of inheritance. But let's say chas v'shalom, that husband passes away and the woman remarries. And this man has never had children before. And she gets pregnant and she has a boy. Now that boy cannot be a petarechem because her rechem was already opened up by the first son of her first marriage. But that son is the first son of his father, who's the second husband. So he is a halachic bechor. So the irony is that a man can marry theoretically 5, 6, or 7 women. If each and every one of them has a firstborn son, he will have a pidyon abed for each and one of those sons. Whereas a woman can be married to a number of men, and provided that the firstborn child who has a natural birth is a boy, each and every one of them is going to be each and every one. Excuse me, I said backwards. A man can never have more than one bechor. A man can have only one bechor. So therefore, even though a man has married many women, only his first son is going to be the bechor. Okay? Now, the more serious question for us, those are all things that happen. We have no control of them. Either you marry these people, you don't marry these people. The more serious question that we have to deal with as lawyers and you as people who write wills is the following question: what is the double portion? And here we get to a very, very tricky problem, which is very, very hard to define. Another common misconception about the bechor is the following: is that the bechor gets a double portion of the estate of the deceased. Not true. It's a misconception. The bechor is only entitled to those assets which are classified in the halacha as what is called muchzak. All of a person's assets can be divided into one or two categories. He can have what is called muchzak, and he can have what is called ra'ui, fitting. Muchzak would be directly translated as a tangible asset which he is directly controlling. Ra'ui would be an asset which it's his, but he doesn't have control of it because it's somewhere else. Okay? So common examples of what would be muchzak would be a guy's house, his car, his clothing, his furniture, anything that's physical and tangible. Cash money. Whereas ra'ui would be something that it's owed to him, but he's not holding on to it. Which would mean if he has an uncollected debt that somebody owes him, that's only ra'ui, that's not muchzak, and the bechor is not entitled to a double portion of it. Here's a tricky example for you that the poskim deal with. A guy's walking down the street, he has 10,000 shekel in cash in his pocket. He's on the way to the bank to deposit into the ATM machine. Okay? Two scenarios. On the way to the ATM machine, he has a heart attack and drops dead in the street and never gets to the ATM machine. According to the halacha, that 10,000 shekels in cash, which is sitting in his pocket, is muchzak. Why? Because it's tangible. He's got direct control over it. And that's muchzak. And the bechor will have a double share out of that money. If he gets to the ATM machine and deposits it in the ATM machine, and then 5 minutes later he drops dead in the street because of a heart attack, according to Rabbi Moshe Feinstein, that's still called muchzak. But according to Rabbi Avad Yosef and many other poskim, no, that is only ra'ui, because he no longer has direct physical control over that 10,000 shekel. It has now been deposited in a bank, and all of us know that money that's being controlled by a bank isn't necessarily directly in your hands, and the bank doesn't like to give out that money very easily. Okay? So it's a whole halachic issue. How do we define what is a person's muchzak and what is a person's ra'ui. And then it becomes difficult for us to determine exactly how much is that Bechor entitled to. Okay, so those are our three problems. Those are our three problems. The problem of the timing. How can you write a will? How can you write a will for something that's going to take effect after you die? Number two, how can you incorporate the woman into the solution and into the will? And number three, what are you going to do with the Bechor? Okay? So solution number one, let's deal with the Bechor, which is really the simplest and the smallest. The recommendation of the poskim is that in your will, you designate a certain amount of money. You set aside a certain amount of money in cash, and you say, this money is to be distributed according to the distribution as prescribed in the Torah. You don't have to mention the Bechor because his portion is subsumed within what's called the Din Torah distribution. In the Din Torah distribution, if it's the man who's passing away, it's going to go past the wife, and it's going to be distributed only among the sons, with the wife and the daughters getting nothing. If there's a Bechor, he will get a double portion. Okay? The question is, how much money do you put into that kitty? That itself is a question among the poskim. There are poskim who say, look, you have to mekayim the din of the Torah somehow. Even if you put in a small amount, a nominal amount, $1,000, $10,000, 1,000 shekel, 10,000 shekel, we can say that you've been yotzei, and you're at least fulfilling that. There are other poskim who say that doesn't make any sense, because if the man is passing away and he has an average. Let's take an average Israeli. Let's say a person who lives in Yerushalayim and he has an apartment, right? An average apartment in Har Nof might be worth 5 million shekel, right? And if he has 5 kids and the daughters are going to get, so that means each kid is going to get 1 million shekel, without even talking about other assets that he might have. And you're going to give the Bechor 10,000 shekel? It's totally disproportionate. And so those poskim say, no, you really should try, don't make a symbolic sum of money. Make a nice sum of money. A sum of money that when a person will get that, one of the boys will get that, they'll say, hey, that's nice. That's really good. I know that a lot of people have a difficult time with this. They don't like the idea of discriminating between their children. However, this is the Din Torah, and this is something that you need to consult with your rabbis. How much am I going to leave according to the Din Torah? That is the solution that we have in our wills for distribution according to Din Torah, and in particular for the Bechor. Giving away a certain sum of money, which specifically says, this I want distributed the way it's written in the Torah. Okay, that's the solution. Solution number 2 is regarding the problem of the timing. How can we write a will? How can we write a will that goes into effect only after we pass away? So there is a provision in the will which turns the entire will into what is known in Halacha as a matnat bari, a matnas bari, which says basically 1 minute before I pass away, all of the things that I've written in my will, all those provisions, they are going to be matanot that I'm giving out 1 minute before I pass away. Okay? And according to this solution, we don't have a normal will. What we have basically is a gigantic gift certificate in which we have given away our wealth a moment before we pass away. Okay? So the will basically has been turned into a shtar matana. Okay? Now, I will mention that the shtar matana is not free of its own halachic problems, because we have a rule in halacha that a person cannot give something davar sheterem ba'alei olam. You cannot give or sell an asset that you don't own. I cannot give away salaries that I have not yet earned. I cannot give away the interest on an investment that I have not made yet. I cannot give away an investment that I haven't made yet. I can't give away a car that I'm not going to buy for another 15 years. Okay? So there are limitations to the matana solution. Okay? Now, however, it is still used, but it is not free of its own halachic implications. The main solution, and this is the one I want to devote the last few minutes of my talk to, is what's called a shtar chatzi zachar, which if we translate it literally would mean a document of half of a man, which doesn't make a lot of sense. but let me explain its background. Already in the Middle Ages, the rabbis saw the changing economic structure and they saw the changing family structure in the Jewish people. And they realized that it was no longer appropriate to disenfranchise women. And it also became a problem when women wanted to remarry or to get married, that they didn't necessarily have enough money available to make them attractive. That's one of the factors. There are many other factors. I have yet to find a good academic research that describes all of the economic forces and social forces that brought about the Shtar Chetzi Zachar. But some of them I think that we can identify. And one of them which we can easily identify is that as time goes by from the ancient times until today, we have moved from an agrarian society in which wealth was defined as how much land you have and maybe how much gold and silver you have, it's more defined today by financial assets. There are some very, very rich people who don't even own any real estate at all. I happen to know a person who is a financial person. He makes a lot of money. His whole wealth is in the financial world. He lives in a rented apartment because it's not worth it for him to invest in real estate. He doesn't think it's a good investment. So the world has changed. And along with that world changing, we already find in the Ramah, in the Shulchan Aruch, 500 years ago, this institution called the Shtar Chetzi Zachar. How does the Shtar Chetzi Zachar work? What we're looking to do is we're looking to take the economic status and the legal status of the wife and the daughters who are outside the realm of inheritance, and we're looking to put them into the equation. We're looking to raise up their status and make the daughters equal to the sons and make the wife over the sons so that she inherits before the sons. In other words, we're looking to get that same flow chart, number 2, that we looked at before, which is what we normally do in a modern will. How does that work? So what the husband does is in the shtar, he creates a financial obligation to his wife and to his daughters by an admission. He is allowed to make an admission in writing that he owes them money. This omission is called an odita in Aramaic, from Lashon hoda'ah in Hebrew, an admission. He admits that he owes them an exorbitant amount of money. Why exorbitant? Because we want the amount of money to be so big that if and when the sons, the halachic heirs, will come to challenge the will that was written, and they will say, our father wrote a non-halachic will. Chas v'shalom. We are halachic Jews. We want things to go according to halacha, and we don't want our mom to get anything, and we don't want our sisters to get anything. So there will be the shtar, and the shtar will say, I am notifying you that I owe my wife a very large sum of money, and the sum of money that we put in is much greater than a person's estimated wealth. If, for example, we meet with a couple and we look at all their assets and we make an estimation, we say, okay, you're worth 10 million shekel. Okay, we're going to put into the shtar 15 million shekel or 20 million shekel. Why? Because first of all, we're hoping in Yirtzeh Hashem that this person will continue to earn money, and that his investments will continue to earn money, and that the real estate that he owns and maybe he lives in is also going to become greater in value. And then Yirtzeh Hashem, when he finally passes away, he won't be worth 10. He'll be worth 15, maybe worth 20. We want to shoot for a number which is well beyond what he's worth today. And that way, if the sons will go to a basin and say, we are challenging our father's secular will. We don't want you, the rabbis on the Basin, to recognize the secular will. We want to inherit according to halacha. Well, the rabbis are going to say, okay, you want to inherit according to halacha? Well, we have a halachic shtar on the table in front of us. And this halachic shtar says that you get nothing because we have debts that have to be paid, first of all, to the wife and afterwards to the daughters. And after we pay all of those debts, from what we see, there's nothing going to be left for you. So you have a choice. Either you agree that the shtar is going to be recognized and that your sisters and your mother are going to get what's coming to them, or we'll enforce the shtar and we'll pay off the debts. And this way, we have created a mechanism by which, al pi halacha, the sons are not going to be able to challenge halachically the validity of the will. Okay, the wife signs a similar one, in which she doesn't have to worry about the first tier between the husband and the wife. She only has to worry about the second tier between the sons and the daughters, and she writes a similar obligation to her daughters. So what we're doing is we're writing a halachic will, which is an appendix to the main will. The main will pretty much looks like a regular will that a regular lawyer would write, but we have a halachic appendix which sits on the side, and nobody needs to see it, because if nobody contests the will, then the main will is going to go through probate, and everything is fine. If one of the sons wants to challenge that main will, and he goes to a Beit Din Rabbani, and he says, no, I don't want any of this secular will stuff. I want to inherit according to the Torah. Then the mother and the daughters will produce the shtar chetzi zachar and say, no, our father also made a shtar chetzi zachar, and he has equated us to your status. And that will be enforced by the Beit Din Rabbani. So basically what we do in our office is we create an appendix, which is both a shtar matana and a shtar chetzi zachar. The shtar chetzi zachar is very common in Israel. In America, is becoming more common. You can find on the internet as many as 5 different shtar chetzi zachars that have been produced by different rabbis. I will mention the RCA has one, Rabbi Willig has one, Rabbi Feivel Cohen has one, Rav Herzl Schechter, I believe, has one, and you can use any one of them. All of them are legitimate. As a final point, I want to implore all of you to watch out and beware of the tendency to DIY, do it yourself, on these matters. A will is not the type of thing that you should be writing on your own, and a halachic will is certainly not something that you should be writing on your own. A will has to be written by a lawyer, preferably by a lawyer who's frum, who understands the halachic issues, who knows how to make the shilub, the combination of the halachic will with the normal will. If you don't have that available, then you can use a regular lawyer, but he needs to work in tandem with a rabbi who is proficient in the laws of Yerusha, because the rabbi needs to tell him what to write and what not to write in the will. Okay? So I think at this point in time, I am going to hand over the floor, the Zoom to Yaakov, because I see that I've gone over my time already. Yaakov, take it away.
Okay, thanks, Pinchas. Can you all hear me? Can you hear me? Okay, good. Okay, I'm Yaakov Greiff. I was at Darchei Noam in, I don't know, about 35 years ago or so, after Pinchas, but before a lot of other people. And I'm pleased to be back with this discussion. I see I only have 7 minutes left. So, and I do want to make sure we do have time for questions. So what I'm going to talk about is just a couple of issues that give some of the practical ramifications of a lot of the theory that Pinchas just gave us. And the way I'm going to do that is I'm going to focus on the question of how many documents does a typical couple use? And I'll give you a hint. The answer is our typical couples need 4 documents. A secular will for each of the husband and wife, and a shtar hilchati for each of the husband and wife. So the first question you might ask in reaching to that number is, like, why do we have a separate shtar that is separated out from the secular wills? A lot of lawyers, especially in Israel, will combine the two together. They'll write a secular will, and then they'll have the halachic language plugged into the same document. And that way they've covered the halachic side and the secular side ostensibly in one document. We don't like that because we've just seen too many examples of court decisions and potential disasters that could happen from having secular authorities trying to interpret the halachic language, which a lot of the times terms in halacha in this field are the same words as they are in secular law, but they don't mean the same thing. And so if you have a judge reading the halachic star, there have been a lot of situations where the disasters have happened of unintended consequences. The most serious of which I think potentially that Pinchas alluded to would be if the IRS in the United States ever got a hold of language that said, I hereby give my assets to my children, they're going to say, oh, that was a gift back when you wrote the will 35 years ago, and we want gift tax plus interest for the last 35 years. I spoke to a legal scholar in the United States who was concerned about that possibility. If, on the other hand, the star language is often one document that you don't ever have to show to the secular authorities, you just have it there because you know, so that your children know that you were concerned about halacha, and so that if somebody ever tries to bring a halacha-based challenge to the dispositions you made, you can see that you signed a star that put it into effect. So that explains why we'd have one set of documents for the halachic side and one set of documents for the secular side, as opposed to the lawyers who like to combine them. We just don't like that. The next question would be, how about one document for each spouse? Why do we do that? Why is it separated like that? Why don't they act jointly? And the answer to that question basically comes down to Israeli law, which is somewhat complicated, and I don't have time to go into the details, although if you bring it up in the questions, we can talk about it. And that is that in Israeli law, the default rule is that no person who is in any way involved in the making of another person's will is ever allowed to inherit from that person. So, for example, if I am making up my will and I plan to give something to my son, but he's also one of my trusted advisors, and I say, hey, what do you think? What should I do about the will? And he says, oh, Dad, I think it's a great idea if you split everything equally between all the kids. He can't get anything from me once he's given me that advice. You're not allowed to be involved, which raises the serious question of, well, what about husbands and wives? They want to be involved with each other's wills. Of course you want to talk over with your spouse. Oh, I'm going to do this. What are you going to do? And so therefore they're going to do joint planning. The Israeli law does allow husbands and wives to be involved. Although it automatically, once they do it together like that, they're automatically into the category of what Israeli secular law calls tzavaot hadadiyot, reciprocal wills. And that reciprocal will problem creates a lot of different ramifications, but the most important of it is that you can't change your will. I myself can't change the will that I made in conjunction with my wife making her will. I can't change my will without involving her in the change because we did the two wills together. If I want to be able to make changes, we have to include in the wills from the beginning a clause that says we're doing our wills together. She's got one document, I've got one document, but we've decided between ourselves that we are going to allow the other one to make changes later on. I'm not going to go into the details of all of that right now because we don't have time, but it's a tricky question about whether you do or don't want to give your spouse the power to change her will after you're gone. A lot of the times I would want my spouse to be able to change her will later on after I'm gone. So that's something that we work into the two wills. We still do them not as one piece of paper, though. It's one piece of paper for each spouse because people usually don't die at the same time. And if it's all on one piece of paper, it gets to be complicated that you have to have turned the will in to take care of the estate of the first one to die. And then meanwhile, you don't have it anymore. And that can get complicated. So that's giving us, now we're up to 4 pieces of paper, one will for each spouse and one star for each spouse. The next question is, how about if you got assets in both the United States and Israel? How many wills do you need? One for Israel and one for the United States? Or can you combine them together? And there are some lawyers, it used to be very routine that lawyers would almost always recommend that each person have one will for his American assets and one will for his Israeli assets. And there are still some lawyers who go that way. We don't anymore. One of the main reasons they used to say that in the past was that it was extremely difficult to get the Israeli authorities to accept a will that was not written in Hebrew. Nowadays, however, it's much easier. There was a little litigation about that some years ago, and you can get a will written in English approved in Israel, which means the language problem doesn't require you to make 2 separate wills, one for the United States and one for Israel. Another reason why you might think that you would need 2 different ones is like, well, the laws are different. Yes, the laws are different, but the laws of figuring out whether a will is kosher or not, according to each secular system, are so similar that virtually any will that's going to be legit in Israel is also going to be legit in the United States and vice versa. And the third reason why there's usually no need for a separate American will nowadays is that we find that most of our clients are not ever going to have to probate the will in the United States for all of the reasons that Pinchas outlined, that most of their assets are going to be financial assets or other assets that are being transferred outside the scope of the estate anyway. And having the will be kosher so that it would work for the United States is mostly just a question of if there were assets in the United States that were forgotten or something like that, and they need the will. And unless it's real estate, there's a really good chance that probate in the United States won't be required anyway, because the financial institutions will accept the probate order from Israel in our practical experience. So that bottom line is it's streamlined. It prevents the possibility of having 2 documents that someone could argue contradict each other. And usually it's appropriate to have just one will for both jurisdictions that's going to be probated first in Israel, because that's where the person lives, and then afterwards in the other jurisdiction. So that gets us to 4. One secular will for each spouse and one star halacha for each spouse. There's only one more thing about the practical aspects of the drafting that I wanted to mention. And this doesn't address the number of documents, this addresses the language. And that is that usually for English-speaking families, we believe it's most of the time it's better to do the will in English because, as I've mentioned, the Israeli probate authorities will accept a will in English. There can be an issue with the land registry when it becomes time for you to transfer title to the land, but the land registry will accept a somewhat unofficial translation, and it's pretty easy to translate from English into Hebrew for purposes of the land registry. It's much harder to go the other direction if somebody in the United States wants to see the Israeli order. And by doing it in English, you end up making sure that no one can ever argue that somehow or another the English-speaking parents didn't understand it or the English-speaking kids didn't get what the parents meant. It makes for greater clarity. I mean, we do wills in Hebrew if it's appropriate for the family, but otherwise not. So I think maybe what I'll do is end with that because the other material that I was thinking of covering is actually somewhat more arcane, and maybe we should let the questions direct
Yaakov,
how that discussion's going to go.
Yaakov, I think that nevertheless you need to take 2 minutes and explain about the federal estate tax And the risk
Oh,
of,
okay. Yeah. That's so much less of a question than it used to be that lawyers almost don't even think about it anymore. But back in the day, when I went to law school, the main point of estate planning was to minimize exposure to American federal estate tax. In nowadays, however, there's no estate tax on an estate of a couple where both spouses are American citizens. There's no federal American estate tax until the estate together, the two spouses' estate is worth $26 million. So most people don't have to worry about that federal estate tax planning anymore because most people in our Lucia do not have $26 million. And therefore there's rarely any estate tax. The one kvetch there, though, that you have to look out for is if you have a mixed marriage, an Israeli spouse and an American spouse, because the Israeli spouse, as a non-resident alien vis-a-vis the United States, her estate has to pay American estate tax on any assets in the United States over $60,000. So that if you have a couple, let's say, and one of them's Israeli or not American, it could be some other nationality too. One of them's not an American, and that spouse ends up surviving the American. The American passes away, and the second spouse is the non-American, and they pass away with more than $60,000. There will be estate tax. So you kind of have to take care of that by saying, well, make sure if I were married to someone who was not American, I would need to make sure that once she inherits from me, that before she dies, she gets rid of the stuff that's in the United States. She can cash it in while she's alive and bring it to Israel so that when she reaches age 120, she won't be holding on to a great deal of American financial assets that her estate's going to have to pay a lot of estate tax on. That's a kvetch that comes about with the mixed marriage couples. But as I was mentioning, in the case of two American citizens, it's pretty rare that you need to worry about it because of that $26 million floor before you have to start paying estate taxes. So maybe we should move to the questions, I'm thinking.
We're going to take questions in just a second. It looks to me like Pinchas has already started responding to some of them in the chat.
they started using some in writing.
Yeah. So
I
maybe
thought we were going to answer them live so that people could hear the answers.
I'm going to read out some of them, and we'll try to get through them quickly. Before we do that, just in case anybody is ready to jump off the call, I just want to say a quick thank you to Yaakov and to Pinchas both I know it took a tremendous amount of time and preparation for both of you. And I have to say that the response to this topic was very much indicative of how important it is to people. So I appreciate both of you very, very much making time to do this. And for all of our participants, I thank you all for being here and being on the call. And I just want to mention that as you hopefully now will all begin to work on your wills and your estate plans, as we've learned, they are really one and the same. I want to mention the opportunity to consider including Shapell's and Midrashet Rachel V'Chaya. Most of you, maybe all of you, already are very strong supporters of the work that we're doing. And with this kind of careful planning, you can ensure that your generosity will continue well into the future and continue to support the future students of Shapell's and of Midrashet Rachel, and really perpetuate the values that you clearly are cultivating in your lifetime. So with that, I'm happy to read out some of the questions, or Pinchas, if you want to direct it since you've kind of been through them, whichever works best for you.
Maybe
I'm
does
actually
anybody,
looking at them right now, and I can.
is there any questions somebody didn't write they want to ask orally?
Let's start with that.
Yeah, hi, it's Yit speaking. Just very curious, we were talking about American assets. How complicated is it to bring over American assets to Israel? Like, for if I have money in the bank account in America and my kid has my will, how complicated is it for them to get my money in America and bring it over to Israel?
Well,
Usually not particularly complicated. I mean, especially if it's a moderate amount of money and not a huge amount of money. Like in our experience, most of the banks, if it's just a straightforward, will distribution, the banks have not been requiring a separate probate proceeding in the state where the bank is located in the United States. They will act on a translated version of the Israeli court order saying, this will is kosher. And they may have to like have a little back and forth with the bank having the lawyer explain what the Israeli law is, but you can usually get the money out that way. One thing that is required is they have to get what's called a federal transfer certificate, which is a like a sort of a permission slip from the IRS that says, there's no federal tax owed on this money before the bank would be allowed to distribute it out over to to Israel. But that takes time, but is not difficult to do. You have to give the IRS a list of all the assets. The IRS looks at the list and says, oh, we see that you have less than $26 million, so there isn't any federal state tax owed on this. And therefore, all these bank accounts that are in the United States, Mr. Bank, you can release this money to the heirs wherever they are, and they're going to be in Israel, and they'll just make a transfer the way you would make any transfer from the United States to Israel.
And there are no taxes in Israel on that money?
There's no inheritance tax in Israel. We have had recently some situations where the banks have inquired of us. They've said the guy who passed away was an Israeli resident who was paying his taxes in Israel, who had assets in the United States that were earning money in the United States. Did he pay Israeli income tax on all that? So, because right after your 10-year Aliyah anniversary, you're supposed to be reporting your interest earnings in the United States to the Israeli tax authorities. And if you haven't been doing that, and you were supposed to, there's accounting kvetches about whether you were supposed to. I'm starting to get the hint that could create some issues. But I just got that letter the other day, and we haven't. The accountant wrote back and said, in this case, the people didn't have to pay taxes or report. So I said, whew, that's a relief. But that's something new that could be coming up. Um, should I answer this first question here about what country decides guardianship of kids living in Israel but are dual U.S. Israeli citizens?
Yeah.
Go for it.
It goes by residence. Principally, it goes by residence. So that if the kids are living here, they need to have a guardian here. If they're living there, they need to have a guardian there. And the same thing, by the way, goes for guardianship for disabled adult children. Like just as you would deal with your underage children, you in your will you can deal with appointing guardians for the disabled adult children, and it would go by where they live. Sometimes they might also need a guardian over there if they have significant assets over there that somebody has to take care of for them. But the principal location would be where they live, without regard to citizenship.
Okay, I'll ask some questions now. I have them
Okay.
very easily accessible. So the question says for BTs, but I'm really going to change it and say for anybody, is there a way or a clause to include in a will that assigns specific Rabbeim that should be consulted for decisions, almost like assigning an expert or a proxy that the court should consult first for any questions of guardianship to other distributive intent?
Absolutely. Yeah, that's a very good thing to do. And that's exactly the type of thing that I mentioned, that when you set up the guardianship, you should say these questions should be determined by Rav such and such, and he should be consulted. And in general, even without guardianship, we normally have in our standard will a seif to say, even without guardianship, people who are elderly, who all their children are grown up, no guardianship is in the picture. There's a seif there for them to say, our Rav, so and so, such and such, telephone number, such and such, email, such and such. He is to be consulted as the halachic authority regarding any question which arises regarding the execution or the interpretation of this will. Yes.
I've even had several cases where
Excuse me, not just BTs. Everybody needs it.
Of
yeah, I
course.
mean, I've had several cases where the client has said to me, before they passed away, my kids are all different. Like one of them's Haredi, one of them's modern Orthodox, and one of them lives in the United States, and they will never agree on a posek among them that they should ask if they have to choose their own posek. So I am going to tell them that I want them to follow my posek. It's Rabbi so and so, and here's his telephone number, and you can write that right into the will.
Okay. Now, some of these may have been answered as we went through it or even now, so we can just skip through them, but I'll ask. If you're dual citizens, do you need to have wills written in both country, or does one country honor the will of the other country?
So they honor the will of the other country, and there are a few explicit, specific situations where we would say you need two wills. Like um, the most common one for us is that someone shows up in the office and they already have a estate plan in place for all of their assets outside of Israel, and it doesn't make any sense to change it because it's fine. They're happy with it. And then we won't cancel that and write a new will for them. We'll just have them suggest that they write a separate will to cover their Israeli assets. That would be the most common situation. Sometimes, if it's a very complicated situation where you know for a fact that probate is going to be required in both countries and that it might be complicated for like a lot of assets of all different kinds, including real estate in both locations, then it might pay to do two separate wills. But most of the time, one will is fine. And by the way, many people come on Aliyah with wills that have already been written that, generically say, like, all my assets should be distributed as follows, and the as follows is what they still want. And now they own some more assets in Israel, and we look at their will for them and we tell them, you don't need to change this. It's okay that this American will be good for Israel.
Okay, great. I think you already addressed this next question. Does it matter if the husband and wife share a bank account? Can we
If
skip
it's a
through
bank
that?
account that's shared in joint tenancy with right of survivorship in America, it's very simple because when one of them passes away, the account will automatically belong 100% to the other one. In Israel, it's more complicated. If they share a bank account, it's the same as the other assets that Pinchas was talking about, that half of half of it already belongs to the one who's still alive, and then the other half gets distributed according to whatever the deceased person wrote in their will.
Okay, this is a tax question. Are estates taxed in Israel when being dispersed or afterwards? What about US-based assets? Are they taxed in Israel when dispersed?
There's no inheritance tax in Israel.
Woohoo!
And even on the real estate taxes also don't apply. The normal real estate taxes you'd have to pay when you sell and buy an apartment don't apply to inheritance. The heirs, when they turn around and sell later, will have to pay taxes, and they have to pay income tax on whatever income they earn from whatever they've inherited. But there's no estate tax or inheritance tax in Israel.
Okay, this one, I know we didn't understand the acronym. In a JT in the USA and one spouse is not a US citizen, is
Um, Hold on a
it
second.
respected by law in the USA?
I understand the question. I didn't know what they meant by JT. So it's a joint tenancy. Okay, so if it's a
Oh,
if it's a joint tenancy, then what that means is that the the surviving spouse who is an Israeli and a non-American, they are not inheriting per se the account. They already own it. They already
Hmm.
own it, and they're just taking full 100% ownership of the account now that their spouse has passed away. So they don't have the $60,000 threshold.
no, when they die, they do.
Oh, you mean the Israeli?
Yeah, later when
Yeah.
after the Israeli has become the full owner 100% of that thing that she used to be a half owner of before her husband passed away. Now she's the 100% owner. When she reaches 120, and if she still owns it, then her estate will be subject to the $60,000 limit. But you're right. At the first stage, no.
Okay, what about in the US if someone inherits from a TOD or as a beneficiary? Do they have to pay taxes on that? And is there a step up to basis in value if you want to sell it later?
Well,
Um,
I already answered that in principle. That's really a tax question, which turns upon facts which are peculiar to any situation. You have to find out what the tax status was of the owner and what's the tax status of the recipient of the beneficiary. It's not something that there's a principle that can be laid down to answer the question.
well,
Okay.
there is. I mean, the general rule though is that a TOD when you receive something from a TO via a TOD or a beneficiary not when you receive when an estate contains even if it's not in the estate officially because it's a TOD, it still gets counted for tax purposes as part of the tax estate. So that if the TOD assets and took you over the $26 million limit, you'd be over the $26 million limit. It would count.
Okay. Um, I think rather than me reading the question, just there was a lot of question about what actually is a Bechor. And I know you went through it actually pretty carefully, but for the purposes of wills, can you just
Okay,
give the quick
okay,
definition of a Bechor?
okay, no problem, no problem. A Bechor is a firstborn son to his father, not to his mother, to his father, that was born uh, through a non-cesarean childbirth. In other words, he had a normal childbirth, non-cesarean. It doesn't have to be. It doesn't have to be a petarechem, and that's why I gave the example that a woman can be married to a man. She will, let's say, have a bechor, and his father will make a very nice pidyon ben, and they will be married for 10 or 15 years. And then chas v'shalom, the husband dies, or chas v'shalom, they get divorced, and she marries another man, and this man has never been married before. He has no children. She gets pregnant for him, and she gives birth to a healthy boy conventionally. So he's not a petarechem because that rechem has already been niftar, right? But it's a firstborn to his father, and he is the bechor to that father. Theoretically, a woman can be the mother to a bechor lenachala an indefinite number of times, congruent to the indefinite number of husbands she marries. Because the bechor, what's important to remember is like this distinction. The easy way to remember it is like this: a bechor lepidyon is defined by his mother. A bechor lenachala is defined by his father, not by his mother.
Think
Hmm.
of it like this. It's kol petarechem as opposed to reshit ono.
Exactly. The word in Parshat Kitetze regarding the Bachur Nachala is Reshit Ono. whereas the word regarding a Bechor Lepidyon in Parshat Bo is a Peter Rechem.
Okay, got it. Great. So if a daughter is born first, then there is no Bechor to that
All
father.
bets are off. No
Correct.
Bechor.
Got it. Okay, is a shtar chatzi zachar potentially problematic in cases of divorce or other similar legal proceedings? I'm not sure what
Well,
those would be.
that was a very good question. Yeah. And
Yeah.
let me put it this way. Not only is the shtar chatzi zachar in danger, but the will itself is in danger. In other words, if you get divorced, one of the first things you have to do is cancel your will because
Yeah.
because you are giving money to your ex-wife or your ex-husband. You don't want that. And one of the first things that you have to do if you're going through divorce proceedings is to cancel that will right away. You don't want not only do you want the shtar chatzi zachar, you don't want the main will. It has to be canceled. Has to be changed.
And if you did the two wills originally as Savaot Hadadiyot, where the husband and wife wrote the wills together, and there are restrictions on their ability to independently cancel each of them his or her own will, you got to send a letter to the ex or the soon-to-be ex saying, "Hey, please take notice. I'm canceling my will. Yours is canceled too," so that both sides know that they can go off and make new wills now.
Yaakov, practically, how do you cancel a will?
So there's a few different ways you can do it. The most common way for people to cancel wills is to write a new one. And in the new will, first of all, if you say nothing in the new will about the old will, then any provisions of the new will that are in conflict with the old will, the new one wins. But most of the time when people write a new will, they will say, "I hereby cancel all of my prior wills." And that affects the cancellation. Or another way you can cancel your will is by tearing it up or, writing in magic marker across the front page, "canceled," so that if you've done that, then the will is also considered officially canceled.
Okay,
And
great.
and if you, with the caveat that if you have this business of having done a will together with your spouse, so that your Israeli wills have become Savaot Hadadiyot, reciprocal wills, subject to various restrictions on separate independent cancellation, you have to jump through the hoops that you're supposed to jump through to cancel. Primarily, that means notifying the spouse that you're canceling. So that way they know that theirs is canceled too.
Okay. Okay, another issue. Does the placing assets in a trust eliminate the halachic issues regarding equalizing the amounts going to the beneficiaries? I'm not sure, but I think what it means is placing the assets in the trust before one passes away. Does that
Creating an inter vivos trust that would
I think I answered that question in writing. I'll reiterate what I wrote there. Is that first of all, the whole something that we didn't get a chance to stress in the main lecture, and I think it's worth stating, is that when I was talking about how Israeli estate planning and American estate planning are heading in opposite directions, the question of trust is a prime example. Trusts are a highly developed legal mechanism in the United States, and it constitutes a very, very effective and common solution for many, many of the problems in estate law in the United States. In contradistinction, while it's true that trusts exist in Israel, relatively speaking, it is a very, very primitively developed area of law. Israeli law does not have a lot of case law. It's not commonly used. And the reasons that people create trusts in the United States are often totally irrelevant in Israel. I mentioned in my talk that People create trusts to avoid estate taxes. Since there are no estate taxes in Israel, you've wiped out about 80% of the reasons why Americans create trusts. Okay? So it's not really necessary. Trusts have a particular problem in halacha in that the poskim do not know exactly how to swallow a trust. Because and that difference also emanates from a difference between Israeli and American law. Yaakov can explain this better than I can, but a trust, explain a legal entity, a trust is a legal entity, Yaakov, for the listeners.
So in the United States, we have had for several generations this whole concept of revocable inter vivos trusts, where like I transfer assets from myself as the trustor into a trust where I'm also the trustee and I'm also the beneficiary. It's a legal fiction. And so therefore, it turns out that as long as I'm alive, I am both the person who created the trust and put the assets into the trust. I'm the person who's running the assets as the trustor, as the trustee, and I am also the person who's getting the benefit of it. It's all just me. And I think I'm not up on how that's viewed halakhically, but I think I recall from looking at this years ago that like that's a fiction in American civil law that's like in halacha, it's meaningless because it's all still in my control. And so therefore I haven't really done anything. If it's a different kind of trust where like I create a non-revocable trust where I can't get rid of the trust, and I give the money to some like third party out there, and I tell him, okay, I'm giving you $1 million. I don't have $1 million, but if I did, I'm giving you $1 million, and I want you to manage that $1 million to benefit such and such an organization. So that means I'm the trustor. The guy I gave the money to is the trustee, and he's supposed to manage the money to benefit the organization. And then at a certain point, perhaps when I die, he's supposed to just give it all over straight out to that organization. There, I've given money to a tzad gimel, and I think that really is money that's taken, that's not in my estate anymore, halachically, right, Pinchas? I mean, that's like giving money to a tzad gimel and telling him, like, when I die, give this money to Joe Blow.
Yeah, I think that's true. I think it's. I mean, in a nutshell, I mean, I'm not really an expert on this question of the status of trust because, as I said, we try and stay away from trusts as much as possible because, first of all, I am a big believer in the adage: number one, if it's not broken, don't fix it, and number two, smaller is better, less is better. And I see trusts sometimes that are these elaborate things that they are totally unnecessary. And another factor which I did not mention, which I did mention in one of the written comments, but it is worth mentioning, is that you have to be careful about setting up trusts here in Israel if you're an American, because an Israeli trust is considered by the American IRS as a foreign trust. And it really is because Israel is a foreign country for the IRS. And a foreign trust is taxable by the IRS. So when we have to set up trusts for our clients, our default path is to set it up as a U.S. trust. Because ostensibly, the whole reason we're setting up these trusts is for U.S. reasons, not for Israeli reasons. So we're going to be setting it up as a U.S. trust to take advantage of the U.S. tax status of a U.S. trust. To set up an Israeli trust for U.S. tax purposes is counterproductive. That makes no sense.
It's all going to be a case by case, and the cases where it's going to be appropriate is rare. I just wanted to see this one right here about the. Somebody had asked whether there's a chance that the wife or daughters could go to Beit Din and try to enforce the Shtar Chatzi Zachar and collect the money and therefore have it turn around and they be the ones taking advantage as opposed to the brothers. And the answer to that question is the versions of the Shtar Chatzi Zachar that we've seen and the ones that we've used all have a specific language in them that prohibit that. They say that the wives can't go to the Beit Din to enforce the shtar unless the brothers have tried to, go against it first. But it has
So
to be written in. It has to be written in like that.
there is a question that we've skipped through, and I think it's actually probably a good way to end. And that is that it's been wonderful learning with you. We've been on the call together for almost 2.5 hours, and everyone stuck it through. Let's
Thank
say we
you.
want to learn more or even get to the point where we actually want to write our wills. What is the process of working with the two of you?
What we have, one of the results of Corona is that a lot of the things that we used to do in person, we moved into writing and we moved onto Zoom. And really, we write many wills for people who only come into our office for the signing. And we can have phone conversations with them. We can have Zoom meetings with them. And we write emails to each other and we have phone conversations. And it really, really works very, very well. The physical presence is really something that more depends upon what our client feels comfortable with them. In other words, I never feel like I need to summon the client into my office to speak to them for my own needs. It's really what the client needs. And I think anybody who wants to write down our emails can write them down and get in touch with us. My email is very simple. My first name, Pinchas, Pinchas, 59 @gmail.com. And Yaakov, tell them what yours is.
Mine is Yaakov.Greiff@gmail.com.
With one A.
YAKOV.Greiff, GREIFF. Two F's. And
At GK Law.
at G, excuse
That's
me,
what
wait
I
a minute.
thought.
I'm sorry. Yaakov.GKLaw. Excuse me, I gave it wrong. Yaakov.GKLaw@gmail.com.
Okay, and we'll send out this information to everybody after.
And I would just say,
Anybody
I would
wants to
just want to add
contact
something
us.
like even if you just want to shoot the breeze about the halacha, like or the secular legal questions, like I'm kind of into it. So like even if you're not calling with a practical question yet, but you're just curious about the topic lishma. My kids will tell you how much I drive them crazy talking about this stuff.
So
And
both
I'm
your
Donna,
emails are
happy
now
to
in the
talk to anybody
chat,
else about it too.
and we'll send them out afterwards as well.
Donna.
Okay,
Thank you,
anything
Donna.
else before we
Donna, I'd like to say, if you can give me 2 minutes,
Take what
I'd like to say something, and this really is intended. It was intended for everybody, and I forgot to say it but I didn't really have time to say it. But if I see that there are 32 participants who are really our hardcore fans who've stuck it out, so I'd like to say this especially to all of you, and this is a bit of a personal message. When the Beis Hamikdash was destroyed 2,000 years ago and Am Yisrael went into Galus, many areas of the Halacha went into Galus as well. And they fell by the wayside, and they were forgotten, and they were neglected. And being in the difficult situation of Galus, a lot of them were not applicable. And in the past 200 years, we have seen a renaissance of the Jewish people in Eretz Yisrael. But during those same 200 years, something else has happened, is that the world has changed radically. The Industrial Revolution, we now live a lifestyle, and we have personal wealth that our great-grandparents and our grandparents could not possibly imagine. And we now have the opportunity, when we write wills and we set up a financial legacy for our family, to do things that our ancestors they couldn't have done it. They didn't have enough money to write a will. If they had written a will, there was nothing to distribute. And, every time that Yaakov and I write a will and a halachic will for somebody in our office, I have this tremendous sipuk, this tremendous personal feeling that I feel that we are redeeming the laws of inheritance, the halachic laws of inheritance. We are redeeming them from galus. We are redeeming them from obscurity. And we're doing it, one will at a time, one couple at a time, one family at a time. But this is something that's very, very personal. Nobody can do this for you. In other words, you have to decide that if you have a bechor, that you want to give him a certain sum of money and you want to give your sons a certain sum of money. And you have to decide that you want to make a halachic will. Nobody is going to volunteer to do this for you. And I would suggest to all of you to join us in that endeavor, whether you use our office or you use another lawyer, you use another rabbi, it doesn't matter. Redeem this area of halacha from galus. Redeem this area of halacha from obscurity. Bring it back into the lives of the Jewish people. And that is my request for all of you who participated tonight.
Amen.
Amen. Thank you both so much, and thank you everybody for being here.